The first thing I noticed wasn't the silence. It wasn't the smell of fresh-cut pine. It wasn't even the giant pile of branches scattered across my backyard. It was the sunlight. For 23 years, the morning sun had filtered gently through a wall of towering cedar trees along my property line. That morning, sunlight poured straight through my living room windows like someone had removed an entire forest overnight. I ran outside barefoot. Half my privacy screen was gone. Nearly 30 mature cedar trees had been cut back so aggressively that they looked like telephone poles with a few branches hanging from the top. Whoever had done it hadn't crossed onto my property by accident. They had deliberately reached over the fence with professional equipment and stripped away years of growth. Then I looked uphill. The neighbor's brand new glass balcony now had a perfect panoramic view of the valley. And suddenly, everything made sense. They hadn't trimmed the trees for safety. They had trimmed them for the view. By the end of that month, they would lose something they valued even more than the scenery: their privacy. My name is Nathan Brooks. I'm a retired landscape architect. For more than 35 years, I designed parks, botanical gardens, and private estates across the state. Trees weren't just decoration to me. They were living structures, windbreaks, wildlife habitat, natural cooling systems, privacy barriers. Every tree along my property had been planted with a purpose. When my wife and I bought our hillside home 23 years earlier, the backyard overlooked a beautiful valley. Unfortunately, so did every house above us. Instead of building a tall fence, I planted 2 rows of western red cedars along the rear property line. I chose them carefully. They grew quickly, handled the local climate well, provided year-round screening, reduced road noise, and gave birds a permanent place to nest. By the time they reached full height, they created a green wall nearly 40 feet tall. People often complimented them. Some even asked for advice about planting similar trees. Then, 2 years ago, the house uphill sold. The new owners were Ryan and Claire Mercer. At first, they seemed friendly. They introduced themselves, brought over homemade cookies, complimented the landscaping. Ryan looked toward the cedar trees. "They're beautiful." "Thank you." "They're also pretty tall." I smiled. That was the idea. He laughed politely. "I guess they block the view." "They do." He didn't say anything else, but I noticed him glancing at the trees several more times. A few weeks later, Ryan stopped by again. "I wanted to ask you something." "Sure." "Would you ever consider trimming those cedars?" "Which ones?" He pointed directly toward the privacy row. "Just enough to improve the view." "No. I'd pay." "I appreciate the offer." "But no." He nodded. I figured I'd ask. Over the next several months, he asked 3 more times. Each time, I politely declined. Eventually, he stopped asking. Or at least, he stopped asking me. One Friday afternoon, my wife and I drove 3 hours away to celebrate our anniversary. We spent the weekend at a quiet lakeside inn. When we returned Sunday evening, everything looked normal from the front of the house. It wasn't until Monday morning that I noticed the sunlight. Then I walked outside. I honestly couldn't believe what I was seeing. The lower 2/3 of nearly every cedar had been stripped bare. Large limbs had been removed. Fresh saw marks covered the trunks. Wood chips littered my garden. Bird nests lay shattered across the lawn. Several irrigation lines had been crushed by falling branches. I immediately checked my security cameras. At 8:14 Saturday morning, a tree service truck parked in front of Ryan's house. 3 workers unloaded climbing gear. Instead of entering his yard, they climbed over his rear retaining wall, then extended boom equipment across the property line. For nearly 6 hours, they removed hundreds of branches from my trees. Ryan stood on his deck most of the morning, pointing, watching, occasionally giving directions. Not once did anyone knock on my door. Not once did anyone ask permission. When the crew finished, Ryan walked to the edge of his deck, looked across the valley, smiled, then raised a coffee mug like he was celebrating. I copied every video file, every camera angle, every timestamp. Then I walked uphill. Ryan answered the door wearing sunglasses and a grin. Hey, Nathan, we need to talk. About the trees? You know about the trees? They look much better. My trees. They were hanging over. They were on my property. They crossed the fence. Branches crossing a boundary don't give you permission to butcher someone else's trees. He shrugged. My arborist said it was fine. I'd like his name. He already left. I looked toward the deck. The valley view was spectacular now, exactly the view he'd wanted. I hope you're happy with it. I am. Good. He smiled. Glad we could agree. We don't. I turned and walked away. That afternoon, I hired an independent consulting arborist. He spent nearly 4 hours inspecting every tree. His final report was painful to read. Several trees had lost more than 60% of their living canopy. Permanent structural damage, increased disease risk, reduced stability during storms, thousands of dollars in restoration work. Some would never recover. Then he asked one simple question. Do you want compensation? Eventually. What do you want first? I looked through my backyard toward Ryan's elevated deck, the same deck that now overlooked not only the valley, but my patio, my kitchen, my bedroom windows, my family gatherings, everything. I smiled. I want my privacy back. He looked confused. How? I have an idea. The next morning, I made one phone call to a landscape contractor I'd worked with for years. By Wednesday, 3 flatbed trucks arrived carrying something Ryan never expected. And by Thursday morning, his $1 million view came with absolutely zero privacy. At exactly 8 o'clock Wednesday morning, the first flatbed truck rolled into my driveway. Then came a second. A third followed only minutes later. The entire neighborhood started watching through their windows. People probably assumed I was replacing the damaged trees. They were only half right. The trucks weren't carrying mature cedars. They were carrying something much faster. 24 oversized modular planter boxes. Each one was custom-built from weather-resistant steel and cedar. Each weighed nearly 2,000 pounds. Each already contained fully grown evergreen bamboo and columnar arborvitae that stood between 18 and 20 feet tall. I'd designed similar living privacy walls years earlier for luxury resorts, where clients wanted immediate screening instead of waiting years for trees to grow. The system wasn't permanent. It wasn't attached to the ground. It required no structural changes. It simply sat entirely on my property, perfectly legal. By 8:30, a crane had started lifting the first planter into position along my rear patio. The bamboo rustled gently in the breeze. Within an hour, the first section of green wall stretched nearly 60 feet. Ryan stepped onto his deck carrying a cup of coffee. He smiled at first, probably thinking I was repairing the landscaping. Then the second truck unloaded. Then the third. By lunchtime, nearly half of his newly opened valley view had disappeared behind a lush wall of greenery. His smile disappeared with it. Around 1 o'clock, he walked quickly down the hill toward my backyard fence. Nathan! I looked up from reviewing the installation plans. Morning. What is all this? My new privacy garden. You can't be serious. I am. You're blocking our view. I looked at him for a moment. You mean the same view you created by cutting my trees? He didn't answer. Instead, he pointed toward the towering planters. Those are ridiculous. They're beautiful. They're too tall. They're on my property. He frowned. You're doing this on purpose. I smiled politely. Yes. For revenge? No. For privacy. He looked around at the workers. You planned this. For about 48 hours. You ordered all this because of the trees? No. I pointed toward my living room windows. I ordered this because I no longer have privacy. He stood there silently. There wasn't much he could argue. Every planter remained well inside my property line. Every measurement complied with local regulations. Nothing crossed the boundary. Nothing touched his land. By Thursday morning, the installation was complete. The result was remarkable. Instead of a traditional fence, my backyard was enclosed by a lush green living wall. The bamboo swayed naturally. The arborvitae added year-round density. Flowering vines softened the lower sections. It looked like something from a high-end botanical garden. My patio was private again. My bedroom windows were hidden. The outdoor dining area disappeared from view. The birds even returned within days. Ryan, however, wasn't nearly as pleased. His panoramic valley view had become a narrow strip of sky above the greenery. 2 days later, I received a letter from the HOA. It claimed my new landscaping violated community aesthetic standards. I laughed out loud. Then I noticed something interesting. My property wasn't part of the HOA. It never had been. The neighborhood had been built years after my house. The association had no authority over my land. I framed the letter. It still hangs in my workshop. 3 days later, another letter arrived. This one came from Ryan's attorney. He demanded that I remove the planters immediately. His argument? They had been installed solely to interfere with his enjoyment of his property. Rebecca Lawson, my attorney, read the letter twice, then smiled. I've been waiting for this. She drafted a response before lunch. It included photographs, survey maps, copies of my independent arborist's report, security camera stills, invoices from the tree service, and one sentence that ended the discussion before it really began. The privacy screening installed on Mr. Brooks' property became necessary only after your client authorized substantial unauthorized trimming of mature trees located entirely on Mr. Brooks' land. A week later, Ryan requested mediation. We met at the County Dispute Resolution Office. The mediator was a retired judge with decades of experience handling property conflicts. He began simply. What outcome are both parties hoping for? Ryan spoke first. I want him to remove those giant planters. The mediator nodded, then looked at me. What would you like? My trees restored. Ryan shifted uncomfortably. They can't be restored overnight. Neither could my privacy. The mediator asked another question. Did you authorize the tree trimming? Ryan hesitated. I hired professionals. That's not what I asked. He looked down. Yes. Were the trees yours? No. Did you have written permission? No. The room fell silent. The mediator closed his notebook. I think we've identified the central issue. No agreement was reached that day. As we were leaving, the mediator quietly said something to both attorneys. This case isn't really about landscaping anymore. It's about property rights. Over the next month, more information surfaced. The tree service company produced its work order. Ryan had specifically instructed the crew to open the valley view. There was no mention of safety, no mention of hazardous limbs, no mention of dead branches, only one objective: improve the view. Then came another surprise. The company's lead climber testified during a pre-trial deposition that he had questioned the job before starting. He had asked whether permission from the neighboring property owner had been obtained. According to his sworn statement, Ryan answered, "They're my trees now. They cross my view." The climber admitted he should have refused the work. His company later settled separately with its insurance carrier over the incident. Meanwhile, my consulting arborist completed his final assessment. Several cedars would recover with years of careful treatment. 5 would require permanent structural pruning. 3 would likely need complete replacement within a decade due to stress and decay. The estimated restoration costs were significant, but the report concluded with one sentence that caught everyone's attention. The privacy function originally provided by the tree line has been substantially reduced. Exactly. That was why the planters existed, not to punish, to replace what had been taken. Then the county planning department became involved. Not because of my landscaping, because of the tree work. The city maintained strict regulations protecting mature trees in hillside neighborhoods. Unauthorized work affecting protected canopy often required permits. Ryan had obtained none. Within days, an inspector visited both properties. Measurements were taken. Photographs documented the damage. Fresh cuts were examined. Permit records were checked. The inspector looked at Ryan. "I can't find any authorization for this work." Ryan's answer was almost identical to every answer he'd given so far. "I thought I didn't need one." The inspector nodded. "That assumption may become expensive." By the end of the month, legal filings filled several binders. Expert reports, survey maps, video footage, arborist evaluations, insurance documents, photographs, witness statements. Every piece told the same story. One neighbor wanted a better view. Instead of asking again, he took it. Now, a judge would decide whether improving one person's view justified permanently damaging another person's property. And when every security camera video was played in court, the entire neighborhood would finally see exactly how those trees had really been trimmed. 3 months later, the case finally went to trial. By then, nearly everyone in the neighborhood knew the story. Some believed Ryan had only trimmed a few overgrown branches. Others believed I had overreacted by installing the towering privacy wall. The truth was somewhere neither side of the rumor mill had accurately described, and that truth was sitting on a hard drive inside my attorney's briefcase. The courtroom filled quickly. Neighbors packed the public seating area. Local reporters occupied the back row. Several certified arborists attended because the case had already attracted attention within the landscaping industry. Property owners came simply because they wanted to know one thing: could someone legally destroy another person's trees just to improve a view? The judge entered promptly at 9 o'clock. After everyone was seated, my attorney, Rebecca Lawson, stood. "Your Honor, this case isn't about whether someone likes trees." She paused. "It's about whether a property owner has the right to permanently alter someone else's property without permission." She pointed toward the evidence table. "And today, we intend to answer that question with facts." Ryan's attorney argued first. He claimed the branches extended toward Ryan's property and interfered with his view. He insisted the trimming was reasonable maintenance performed by professionals. Then he added something unexpected. "My client never intended permanent damage." Rebecca didn't interrupt. She simply smiled. Because intent wasn't the issue anymore. Evidence was. The first witness was my consulting arborist. He explained how western red cedars grow, how removing large portions of the lower canopy permanently changes their structure, how aggressive pruning exposes trees to disease, insect damage, and storm failure. The judge listened carefully, then asked, "Can mature trees recover completely from this type of pruning?" The arborist answered honestly, "Some can improve. But they never return to what they were. So the privacy they once provided? It's permanently reduced." Next came photographs taken before the trimming. Towering green walls, dense foliage, complete backyard privacy. Then came photographs taken afterward. Bare trunks, missing limbs, visible saw cuts, open sightlines directly into my home. Several people in the gallery quietly shook their heads. Then Rebecca turned toward the judge. "Your Honor, I'd like to play Exhibit 21. The courtroom lights dimmed. Security camera footage appeared on the large screen. Saturday morning, 8:14 a.m. Ryan greeted the tree crew. He pointed directly toward my cedar row. The crew climbed into position. Instead of remaining above Ryan's property, they extended equipment across the property line. Chainsaws started. Branches fell. Truck after truck filled with freshly cut limbs. The video continued for nearly 20 minutes. No emergency, no storm damage, no dangerous branches, no attempt to contact me. Only repeated instructions from Ryan pointing toward sections of my trees. At one point, the lead climber even climbed onto equipment positioned beyond the fence. The courtroom became completely silent. When the lights came back on, the judge looked toward Ryan. "Were you present during this work?" "Yes." "Did you authorize it?" "Yes." "Did you own those trees?" "No." "Did you have written permission?" "No." The answers were short. The consequences wouldn't be. The owner of the tree service company testified next. He admitted his company should have requested proof of ownership before beginning work. He also confirmed that Ryan's written work order stated, "Open panoramic valley view." There was no mention of hazard reduction, no mention of storm damage, no emergency, simply a better view. During cross-examination, Rebecca asked one final question. If Mr. Brooks had answered the door that morning and refused permission, would your crew have continued? The owner immediately replied, "No." That answer echoed throughout the courtroom, because it proved something important. Everyone involved understood permission mattered. No one bothered to get it. The county tree preservation inspector testified afterward. He explained that several of the cedars qualified as protected mature landscape trees under local regulations. The required permits had never been requested. The inspector also confirmed that unauthorized pruning on protected trees could result in civil penalties. Ryan lowered his head. His attorney no longer looked confident. When it was Ryan's turn to testify, the judge asked the question everyone had been waiting for. "Mr. Mercer, why didn't you simply accept your neighbor's decision when he declined your request?" Ryan hesitated. Finally, he answered quietly, "I thought he was being unreasonable." The judge nodded. "And because you believed he was unreasonable, you decided to make the decision yourself?" Ryan didn't answer. He didn't need to. The silence said enough. Closing arguments were brief. Rebecca reminded the court that property rights don't disappear simply because someone wants a better view. She explained that replacing privacy after mature trees are damaged requires years of growth or significant expense. She also pointed toward photographs of my new privacy wall. "My client didn't install these planters to punish anyone. He installed them because the privacy his trees once provided had been taken away." 2 weeks later, everyone returned for the judge's ruling. The courtroom was packed again. The judge spoke slowly. "The evidence clearly establishes that Mr. Brooks owned the trees." He continued. "The defendant knowingly authorized substantial pruning without obtaining the owner's consent. He confirmed that the work permanently reduced the tree's screening value and caused measurable damage. The judge ordered Ryan to compensate me for the cost of restoring the landscape, replacing trees that could not recover, and reimbursing expert fees and legal expenses where permitted by law. The tree service company, having reached its own settlement through insurance, was dismissed according to that agreement." Then the judge addressed the privacy wall. "The screening installed by Mr. Brooks is located entirely on his own property. It complies with applicable regulations. It serves a legitimate privacy purpose. The court finds no basis to require its removal." A quiet murmur spread through the gallery. Ryan stared at the floor. Outside the courthouse, reporters waited. I declined interviews. Instead, I drove home. Over the following months, certified arborists worked carefully to help the damaged cedars recover as much as possible. Some responded well. Others would never look the same again. The modular privacy wall remained. Birds returned. The garden flourished. Climbing vines covered portions of the planters until they blended naturally into the landscape. One afternoon, nearly a year later, I saw Ryan walking along the sidewalk. He stopped near the fence. "I owe you an apology." I looked at him. "I should have respected your answer the first time." I nodded. "That would have saved us both a lot of trouble." He looked toward the cedar trees. "I wanted a better view. And I wanted privacy." He smiled sadly. "I guess we both got what we asked for." Maybe he was right. His valley view had disappeared behind a living wall. My privacy had returned. The difference was that mine had been rebuilt on my own property. His had been lost because he chose to ignore someone else's. Sometimes neighbors don't end up in court because of fences. Sometimes they end up there because one person forgets that respect for a property line begins long before the survey stakes. It begins with asking and accepting the answer, even when it's no. If you enjoyed this story, don't forget to like, share, and subscribe to the channel for more powerful HOA stories, courtroom drama, justice-served stories, and unforgettable endings every week. Turn on the notification bell so you never miss our next story. Thanks for watching, and we'll see you in the next one.